attempt to do a screen share of it, but it would be nice to have it in front of you if you want to take notes on it or, you know, follow along as we go. All of you, if you're not from KW and you're from a different brokerage, that's great. But I'm assuming, I know KW, I think, has in your documents that new contract, and hopefully if you're from a different brokerage, they've got it out to all of you as well. Does anyone have an inability to access that new contract or questions on that? And feel free to jump in if you've got a question, unmute yourself and just get my attention, or if you want to do it on the chat, I'm going to keep my eye on that too. But otherwise, we're going to get started. So what happens is, for those of you who don't know, Columbus Realtors basically have a committee called the Standard Forms Committee, and their entire function is to go through and periodically update, and some people would say make longer your standard purchase contract that you're using. And they just came out with some recent changes, and that's what we're going to be going over today. The main, I hear someone. If you are not muted, how about this? Try and stay muted unless you're talking, and then unmute if you want to talk. That way there's not a lot of background noise. This is not my Zoom account, so I don't have the ability to mute everybody yet. All right, so we're going to get started. The majority of the changes we're going to talk about today have to do with changes to paragraph 6.5, having to do with condos and HOAs. I suspect that's why a lot of you are here, but that's going to be the bulk of the meat of what we talk about. So I'm going to go over the other minor things first, and then we'll get to 6.5. Okay. So we're going to start. I'm going to do my screen share here. I've got the new contract up here, and I've got the annotated version. The annotated version is the version. Can you all see that? Can you see my screen share? No? Okay, hold on one second.
No.
Sorry. Can you see it now?
No.
You can, how about now?
It's telling us, there we go.
You got it? Okay. All right, so this is the annotated version. What the annotated version is it's got comments on there. Bill Fergus is an attorney who heads up this committee and has for years, and he kind of puts in italics below each section the reasons and kind of a little explanation for the language that's in there. So we're going to start at 3.2. There was some changes to this appraisal language. All that happened here is, what did they do? 3.2D. They basically changed this to take into account lender opinions of value that are not based on appraisals. And people asked, the last time I did this informational, they said, why did they do this? Apparently there are certain of these government servicers who take loans that are not requiring full appraisal. So sometimes you don't have a full appraisal to give under this language. So what they did is they changed it to say a copy of the appraisal or other documentation evidencing the lender's determination of value. So that's kind of a technical little change, but basically it's allowing for different evidence if there was not a full appraisal done. So that's a pretty quick change, but just be aware that it's in there. Let's see. We're going to go down now to, I'm going to skip over here. 6.1, inspections and tests. This is again a very minor change, but hopefully all of you know that the state of Ohio implemented basically saying inspectors have to get licensed. And what this did now is it reflected that to say in this first paragraph of 6.1, it talks about this recommendation, a qualified person who is exempt from home inspector licensure requirements pursuant to, and it's referencing that section. So it's saying they're recommending, the broker further recommends inspections and tests be performed by a home inspector duly licensed by the state of Ohio, or with respect to specific components or conditions, it should be a qualified person exempt from that. So there's certain types of inspections that could go under certain conditions that are exempted. If you go to this section of the revised code, it talks all about the new licensure. I believe a lot of this was delayed because there was supposed to be an effective date of the new licensing, and because of COVID and everything else, I don't know that they have said that they've reached the effective date because they were working on putting together a bunch of guidelines to govern this inspector licensing. But just be aware, the contract just got updated here to reflect that there is now a law requiring inspector licensing. Pretty minor change there also. Again, jump in and unmute yourself if you've got questions on this stuff as we go along. I'm going to go pretty quick to get to the condo HOA stuff because that's, again, the meat of most of the changes. We're going to go down to 7.2. There's a quick change down there. There's 7, what does he say here? Gas line, there was a section in here that talked about gas line warranty protection plan, and that's been deleted because most home warranty plans now already include your gas line warranty protection. So you'll notice that that language that used to be in there about gas lines is no longer here. Normally they just add stuff, but they actually did delete something. And then there's another quick like technical change to 13. And this is updated because of text messages, because of how much we're using those. So what they did in 13.5, they say contract documents, and they're talking about what constitutes a signature on your documents. And it says manual or electronic signatures transmitted in original or fax, including photocopies, faxes, PDFs, scanned documents sent by any method are valid. But it says for the purposes of this provision, contract documents do not include voicemail, email messages, or text messages. So be aware that that's excluded. A text message does not count as a contract document. And then it talks about in 13.6, they modified it to say that notices can be delivered via text. So notice via text is valid. It's just that texts are not going to count as a contract document. So they added into 13.6 to include text, but in 13.5, they made clear that a contract document is not going to include those items. Okay. All right, so those are most of the changes, but we are going to get in here 2 different sections involving condos and HOAs, 6.5 and then 10.4. And 6.5 is the real biggie. I can tell you, I sit on the committee that makes all these changes, and we spent a good portion of last year, the beginning of this year, working on this. And it doesn't make a lot of people happy because when you first look at it, I think most agents are saying this requires a lot more work, and why are we having to do this? Seems to be the initial reaction about getting all these condo docs. That said, the reason the committee and the Columbus board thinks it's so important is because they feel like a lot of people are representing buyers and sellers where there's a condo association or a homeowners association, and they don't fully understand the law with regard, not that you're attorneys, I know you're not, but they don't fully understand the implications of when this type of community that's got these restrictions and that's set up this way, like a condo association or an HOA, the implications on your buyer and your seller. So I think traditionally, we used to have that long condo HOA checklist. And I think a lot of people weren't using it. And I teach a 3-hour class on this subject, and I have for years and years. And I know a lot of people weren't using it because they would flat out tell me. And when I asked why they weren't using it, oftentimes the response would be, well, I'm not going to be able to get all that stuff from my, for my listing. So I don't have it all. And then buyer's agents were reluctant to include it in their offer because they said, we're in a pretty competitive market when we are. And I don't want my offer thrown out because I put this addendum on and asked for all this extra stuff. If you're shaking your head or saying, yeah, that makes sense. I think a lot of people have thought that. The problem with that thinking is these documents that you're not getting for your client or not asking for are pretty crucial to the property they're buying. So from the board's perspective, this stuff is important enough that they said, we need to level the playing field. We need to make these things a requirement in the contract. So we're not relying upon people trying to either not use the addendum or deciding on behalf of their client that they're not going to use the addendum. So by putting it in the contract, it's going to very much at least force a conversation with your buyer about these are the things that the Columbus area board thinks you should have. And if you're really not going to ask for these things, you better have a conversation with your client to educate them that you're excluding this. So let's go over what it says. What it's going to say under 6.5. So this is it. It's the condo or HOA association document provision. If it says, if the premises is a condominium unit that's governed by an association, which pretty much every condominium unit's going to be, or it's located within a community governed by an HOA. So that would be your subdivision that's got a homeowners association. The seller shall provide buyer with the following information and documents within 5 calendar days after the date of acceptance. And then it's going to go through this whole list of items. It's got on here condominium declaration and or deed restrictions and bylaws of the owners association, including all amendments to those things, except you don't have to provide a bunch of amendments that just increase the number of units or homes. So if you're not sure what these things are, what they mean, I would really encourage you to come to my 3-hour class coming up on condo HOA. That one is a CE class, and it goes into great detail about what these documents are, what they mean. It will help you understand them. But essentially, this is what your buyer is going to want to know as to what they can and can't do with that property from the time that the property was first created and the developer filed these restrictions and any amendments to those things. So if 10 years later, a board got together and said, we're going to restrict leasing on these condos, that would be done by an amendment. So this is making sure that your buyer knows what they're getting when they purchase the property. There are something called expansion amendments where all those amendments do is say, you know, developer built 10 units initially, and then they file an expansion amendment to build 10 more. They're saying you don't need to give every single one of those expansion amendments. Those aren't substantive. It doesn't really affect your buyer's ability to what they're going to do with that property. Moving on from that point, it says you've got to provide condominium board and management company contact information, name, phone, and email. Contact information for any other mandatory membership association. That comes into play because some of these communities have 2 different associations that you have to become a member of when you buy. And if the seller hasn't disclosed that, it becomes a problem for your buyer, who all of a sudden might be getting a second invoice for a monthly or annual or quarterly fee that they didn't know about. And it's very hard as the title company, if a seller's not disclosing that to us, we don't necessarily know of the existence sometimes of that second association. It talks about giving a statement from the association regarding the particular property, confirming when the next assessment payment's due, the amount of the payment, the amount of any special pending assessments, and whether or not the account is current. This one's really important so that your buyer knows what they're going to be responsible for financially in these communities. It also is going to require you to provide information on any association initiation fee, reserve contribution, or transfer fee. Minutes from the last 3 minutes of the directors or trustees, that helps people know, again, what they're getting into and what's going on at that community. And then minutes from the last meeting of the members of the owners association, and that usually is an annual meeting. The most recent version of unrecorded rules and regulations, those are going to be what are called like the house rules or handbook of an association, and the boards from time to time pass those. So again, important stuff is in there. It's not recorded with the county, and your buyer's going to want to see that. They're going to want to know if they can only have 1 dog instead of 2, or you know, they can't park their vehicles overnight in certain areas. They're going to want to know all of that. Current financial statement showing the nature of the association's assets. So the most current balance sheets, income and expense statements, and budget. Copy of the most recent reserve study. Those are all important documents for assessing the financial health of the association. Your client might not care, but it's a disservice to them to not let them know what kind of shape the place is in, because that's going to be very telling as to their investment in the property and how their property values might go once they buy in. Questions on any of that? I'm going to stop the screen share for a minute. Any questions at all from anyone on those documents? Stacy, I see you waving your hand.
So I just want to make sure, because I know where I live, I have a website that I can go to and look at all of our condo docs. And
Right.
so for the last transaction, I just gave the agent, here's the website, like,
Mhm.
and they went and got whatever, they needed. It, by having this in here, and if we give them the website, is that sufficient, or we have to actually pull the docs and send them to them? And
I think as long as you've got something in writing, so if you've got the website and you're confident all of this stuff is on there, I might put, even put together a quick addendum that all parties agree that 6.5A was satisfied by virtue of that information being provided on the website. So just something to kind of tie it up to make sure that they're not coming back later. And we're going to go over the timeframes, but you don't want them to be able to come back later because they're trying to get out for some other reason and say, hey, you didn't provide me this stuff. So I think you can do it that way, as long as you put together something in writing, a quick addendum to say all parties agree that this provision was satisfied. Does that make sense?
yeah.
And
It'll be faster than having to send all the stuff to them. And if you do it once and get that language for your addendum, you could use it repeatedly. Some associations have these websites and they don't like are password protected, and you might not feel comfortable giving that information. Only the seller usually has a right to this because they're the titled owner. So it kind of all depends. And I can tell you the board's going to be doing a bunch of teaching on these topics. What they want to get the industry to do as a whole is for listing agents to get in the habit of going to your listing appointment and saying, seller, we're responsible to have all this stuff ready, and getting it ahead of time. Because nobody wants to be scrambling around trying to hunt all this stuff down after the fact when you're under the gun and you've got a time frame. So they want to educate listing agents. And by the way, guys, so under Ohio law, only the seller has the legal right to all this stuff from the board. If you as the agent try and call the management company to get all this stuff, you probably won't get a call back, or you'll get an attitude, or they'll say, we don't have to talk to you. They don't. But legally under Ohio law, they do have to talk to your seller, the owner of the property. So the seller should really be the one, practically, I think, to go to get this information gathered up before you even list.
And all of these are,
Stacy, go ahead.
we're not asking any association, none of this is asking them for something they don't already have, right?
Correct.
Okay.
They should have all of this stuff. Now, the only one I would say they might not, that very bottom one, their reserve study. Some associations haven't gotten that done. What a reserve study is it's essentially an assessment of the condition of the big capital items at a property. So if it's a condo and they're responsible for the roads and the siding and the roofs, those are big capital items. They should have a reserve study that basically goes through and states, here's the condition of those big items, here's how much useful life is left in them, and it kind of assesses it's financial planning for the long-term future. If they don't have one, that's an indication that the law changed in 2004, so that's a long time ago, that's 16 years ago, requiring these condo associations to not do these huge special assessments for those big capital items, unless there's certain things they could do where they're allowed to, but there's a bunch of steps they have to follow under the law. So if they are looking at you saying, I don't even know what you're talking about, I don't know what a reserve study is, to me, that's an indication of poor financial health right there, but that's my opinion. But there could be some places that don't have a reserve study, okay? So if that's the case, and I've had people say, well, what if I can't get this stuff? So maybe you just do a quick addendum to say, parties agree that everything has been provided under 6.4 to buyer within the time frame, with the exception of a reserve study because it doesn't exist. Just something to document what you've gotten. As far as everything else on there, they should have it. Rules and regulations, I suppose if it's a smaller place, maybe they never pass those, because those are passed by the elected board and they can change every year. So notice it says most recent version. If you get a book of rules and regulations and it's dated 2001, I would be concerned that that's not the most recent version. That could change every single year that a new board gets elected. So be aware of that. And again, those are the one item that's not the one item. They're not recorded like other deed restrictions are. So it affects your client's ability of what they can do with the property, but is not necessarily recorded. Somebody else was going to jump in. Was it you, Tracy Edwards? I don't know. I thought someone was trying to talk a minute ago, but I don't. Yay, nay.
Yes, but you covered it. I was going to say that most, condo association websites can't be accessed but by anybody but the owner. So,
Right.
Yeah, but you covered that. So,
right. And
Yeah.
so they might not be comfortable saying, I'm going to give out my password credentials for that. So if you can access it, great. But if it's password protected and you don't necessarily want to do that, you might want to. A lot of agents I'm talking to are saying they're just going to get this stuff in advance and put it. And I'm not an MLS expert because I don't ever have to go on there to do anything, but there's a place where they would just upload and put all the documents that they have. I kind of ran it by the last time I taught this about a month ago. And one of the concerns was, can we put all the financial information up like that in the MLS? And I talked it through with Bill Fergus and a couple, another attorney that's on that committee, and no one really saw a problem with doing it that way, with putting it on the MLS and having it all up there. So the idea behind all this again, and
Marie, sorry to interrupt, Marie.
No,
As
fine.
long as you click private on the documents instead of public,
Okay.
that only allows licensed agents to see it. The general public will not see it on Zillow or anywhere else.
I think that's a great idea. Yeah.
Yeah, should be, yeah.
So Tracy, that's good to know. And please jump in, because like I said, I'm not familiar with the MLS and how that works. So you guys know better than I, but that's a very good point. And I don't think there's anything that's like super private about it, but I don't know that people want that share, all of these details shared beyond someone who's actually a prospective buyer that you're giving it to, or rather the agent for the prospective buyer. So again, the ideal here is going to be that seller, you take this list with you to your listing appointment and say, you find, it when there's a condo, you need this. If there's a homeowners association in another type of home, you sit down with your seller and say, this is what the contract requires. I always give this practical tip. Your seller and buyer have a right under Ohio law to get this stuff. It has nothing to do with them selling their unit. They just have a right to have it for their records. So if I am a seller trying to compile this and I have to go to my management company, I'm not even mentioning that I'm selling the property. Because as soon as they mention that they're selling, then they're going to start saying, well, let's charge you the hundreds of dollars for condo certs, or put you into that system that takes a lot longer. The title company is going to have to order all the documents through that mechanism anyway, because we can't trust, we're not allowed to just trust that the seller gave us the right stuff. We have to order it through the management company. But to get this ahead of time for your guys' sake, I'm telling my seller to go to the management company and get this stuff, and not even to mention they're selling the unit. Not to be deceitful, but it's none of the management company's business. And like I said, there's a provision in the Ohio Revised Code that says you've got a right to get this stuff as the owner of the property. So the only thing they really should charge your seller at that point, if they don't, and this is assuming they don't have this stuff online. A lot of the times they have websites like Stacy mentioned at the beginning where it's online. But let's say they don't have a website, they don't have it online. The only thing that they're supposed to be allowed to charge your seller is what's called a reasonable copying fee under the Ohio law. So that could be that they would say, you can come into the management company office and copy these documents, and it's going to be 5 or 10 cents a page. Okay. So again, I'm not mentioning that I'm selling. I'm just saying, I want to get my documents in order for my property, and I'd like copies of this stuff. If they know a member of the board member probably has electronic copies of all this that they could just email them. There's no incentive. There shouldn't be an incentive for a board member to not provide this stuff to an owner. And it sometimes feels like, it's like, why is it so hard for the seller to get this stuff? It feels like, the management company and the board don't want to release this. Well, there's no reason they shouldn't not want properties to sell in their community. And there's no reason for them to withhold the information. Yeah, I'm not saying management companies are easy always to work with, because unfortunately, that's just not the experience I've had. They can be difficult to work with. Any questions on getting this stuff in order? Okay, so you've got 5 days unless you modify it. What the contract's going to say is 5 days. And there's this, what's called in 6.5B now, there's going to be a review period. So what it says is, Buyer's obligations are contingent on upon satisfactory review of the documents provided pursuant to that 6.5A that we just went through. Buyer has 5 calendar days after receipt of the last delivered documents, or 10 calendar days after the date of acceptance of the contract, whichever occurs first, to review the documents. So if buyer's not provided some or all of them, or is not satisfied with any of these requested documents, their sole remedy is to deliver a notice of termination. Earnest money then gets returned. Well, as long as everyone signs off, the contract says it's supposed to go back to buyer, okay? Buyer's failure to deliver the written notice of termination within 5 calendar days following the receipt of the documents, or 10 calendar days after acceptance, whichever occurs first, constitutes a waiver of buyer's right to terminate pursuant to this provision. So this is set up like other provisions in the contract that you see. It says it does not limit the buyer's right to object to matters set forth on the title commitment, which is another section of the contract, okay? So there's this review period. If you think 10 days is way too long, you can negotiate something different, just like you could negotiate any of your other timeframes in the contract. But this was what seemed to be most reasonable to give. Now, let's say your seller's got everything together and you don't need the 5 days and you're going to provide it. You've already put it all on the MLS. At that point, if they've got everything right away, it's not going to extend it to a 10-day because they've got everything. So the review period would really be 5 days into the contract. So by day 5, you would know whether or not they were trying to terminate or whether they accepted what you gave them. I do think, like any time frame in the contract, it's a good idea to document. So if you know that you've got all of your documentation in order on the day that you go into contract, I still think you do something quickly in writing to say, even if it's an email to say, to the other agent, so we agree that you have everything you need under 6.5A today, so that our review period will end on X date. Does that make sense to everybody? 5 days later, so that you're on the same page and you're not getting into a dispute about dates and termination based upon these provisions. Okay. Questions on that? So this is it's kind of just like, it's set up like an inspection or like any of these other contingencies in the contract where it's like, these time periods are in place, the buyer gets it, they don't like what's in it, they have a period of time to terminate. And as long as they're following it and legitimately everything happens during the required timeframes, if they want to terminate inside or in that time frame and they do, the earnest money is supposed to go back to them. Now, we all know earnest money can get held up if both parties don't sign, so that doesn't take it out of the Ohio Revised Code requires both parties sign for it to go back to anybody or for it to go to anybody. If you look at the italicized language in here, this is kind of, again, the explanation for the changes. Paragraph 6.5 brings the most important condo HOA documents to the attention of the buyer. In the same way, a home inspection informs the buyer of the physical condition of a property. This allows the buyer to avoid surprises in solvency of the HOA or condo, upcoming assessments, rules and regulations that could make a difference in their decision to purchase. And it gives some examples of pet policy, ability to lease, parking prohibitions, storage of trailers or boats, upkeep, landscape maintenance, etc. And then it talks about how 6.5B creates a contract contingency, allowing buyer to terminate the purchase contract if they're not satisfied with what they see, similar to a home inspection contingency. Listing agents should note that MLS will alert you of this contract provision whenever you list a property governed by condo or HOA. Listing agents should work with their sellers to procure all listed documents before putting the property on the market. Best practice is to notify buyers as soon as possible if some or all of the requested documents do not exist or will not be made available. Okay, so that's the explanation. That won't be, when you pull up your actual contract to use this italicized language is not there. This is just in this version that I'm showing you to kind of explain everything. Okay, any questions? There's a lot in there. Okay, can buyer waive the request for these documents until closing? They certainly could, but if you're representing a buyer and they do that, you better make sure you understand and can explain to your buyer what these documents are and what it means, the implication for them to be waiving them. And I'm also recommending they seek an attorney opinion before they waive those. So you can, but if you just say to a buyer, I think we should point blank delete 6.5A without explaining to them what that means. I think you're putting yourself in a position of risk because the board has now decided this stuff's important enough to be in the contract. So you're putting yourself in a bit of a risky position if you recommend waiving it and you don't fully understand or have not fully explained to your client or recommended they seek counsel to make that decision to waive all of that. Does that make sense? Let me see who asked that question. I'm trying to get to my chat. Jacqueline. So hopefully that makes sense. You know, you can do it certainly, but like anything else, you know how we would never recommend waiving an inspection, certainly. This is kind of, you should think of it in the same way. If you're recommending it be waived, you better make sure that you recommended counsel and that they understand what they're waiving. Okay, any other questions?
Sorry, this is Tom.
Go ahead.
Are you able to share that? Are you able to share that document so we can see some of those notes made by the attorney?
Yes, I am able to share it. And I think that it's out in, yeah, I'll share it. Do me a favor. I'm going to put in the group chat my email. If you want a copy of this, shoot me an email. Just because this isn't CE, so we didn't have you guys do like a sign in to track everybody. If you want a copy of this annotated, shoot me an email and I'll get it out to you all.
Okay, great. Thank you.
No problem. Okay. I just put my email in the chat. So if you can see the chat, it's just marie@titleconnectagency.com. Shoot me an email that says, can I get a copy of the annotated contract? If you do not hear back from me, we have a really a very strong filtering system due to our the title company requirements we have. So I'm going to also give you my cell phone number on here. And if you don't get a response back, you can reach me this way if you don't have my info. Let's see. So kind of one more thing, and we don't have to go the whole hour if people don't have questions, but I'm going to promote to you guys that we have a 3-hour condo HOA class coming up. So if you, and that one is for credit. If you don't understand what the heck I'm talking about when I'm going through these documents, if you come to that class, you will know what those documents are. Bear with me 1 second. I got to bend down to grab my calendar. I'm going to tell you guys when that condo HOA class is so you can notate it if you want to attend, and it'll be done just like this on Zoom. Let's see. It is on September 24th, so it's later this month.
Is it possible for you to send a pointed list of what the changes are?
This is all in, there's an article by Bill Fergus that was in the last In Contract magazine. So if you have access to get to that online, it's all there. I can try and, again, if you want to email me, I'll send you over. He's got an article and then his annotated version is all in that last In Contract. If you don't have access to that, I can try and send it to you. Yeah, he did a quick summary in the article that's in Contract of what we just went through. So shoot me an email if you don't have that and just tell me what you're looking for. So that condo HOA is on September 24th from 9 to noon. It's painful to do these Zoom classes for that long. I understand it's painful for you guys to sit there for that long. I'm going to try and do it in a little bit different format. There'll be breaks. We're going to try and do maybe some breakout even with discussion or something to make it a little more bearable to sit in front of your computer for 3 straight hours. One more change that goes along with the condo HOA. You guys can still see my share screen. I'm going to go down to 10.4. There has been historically some disagreements over who's going to pay for what with regard to these associations. They all charge different fees when a unit or home sells, and oftentimes they call them different things, so you don't necessarily always know. Once in a while, a seller's not even sure what all their association is charging when they sell. So it doesn't come to light until the title company starts getting the information we need. And then we say, wait, there's all these charges, who's paying for them? So 10.4 attempts to address this. It says at closings for condominium properties or properties subject to a homeowners association, buyers shall pay all initial reserves and or capital contributions that are charged by any owners association, condominium or otherwise, or civic association in connection with the sale or transfer of the premises, as well as any fees associated with lender required document costs. So all of that's going to fall on your buyer. If it can be lumped into that category. Seller shall pay all of.
Oh,
Hello, yeah. Hello? Was someone just talking? Okay. Seller is going to pay all other fees that are charged in connection with the sale or transfer of the premises, including without limitation, all transfer, processing, expediting, delivery, statement, or management company fees. Again, we can't cover every different name these associations and management companies have decided to call these different types of fees. To me, the best practice is making sure as a listing agent or on the other side that you are very clear at the point of entering into the contract what all is going to be charged, that you found out what those fees look like. And that way, if you want to negotiate differently from what's in 10.4, you can do that. If you want to say, this is a seller's market, we're going to make the buyer pay all of it. Great, negotiate that and put it in an addendum, but be clear on what this says, because the title company has to follow what's in here. So we do our best to figure out what they're calling the fee and put it on the appropriate side based on the language that is here. If you want it to be paid differently, you've got to do an addendum or negotiate that at the outset of the contract. Okay? What other questions do we have? I know we went through that pretty fast. We've got about 10 to 15 minutes with additional time for questions here on these fees, on these documents, on any of this stuff. And again, if you aren't sure what this stuff is, especially if you're a newer agent, please come to that class and I promise you will know what it all is after that. The idea, I'm going to summarize again, the idea behind this is that your buyer is not going in and buying a property having no clue what types of restrictions are on it that would affect their use, and having no clue about the financial health. The association here, financial health, greatly impacts the individual property value. And to have no idea what that looks like is a disservice to the client. And if you've been lucky enough not to have a client upset with you when they move into a place and find out it's in really bad financial shape, or that they can't have their beloved dog or boat or whatever, you're lucky if you haven't been in that position. You don't certainly want to be in that position. And these changes are intended to make sure that your buyers are in the know about what they're buying and can make an educated decision before they decide to purchase into one of these types of communities.
Marie?
Yes.
We're not obligated to interpret the documents though, correct?
No.
We're just to provide them.
Absolutely. And Stacy asked, should you guys interpret them? No, absolutely not. I would actually actively discourage you not to interpret them because that would be practice of law essentially. So what you can do is you can give them to them. And what I always say is you should be telling, when your client gets these documents, so let's say you're representing a buyer, the listing agent has provided all of these to you and you're giving them to your buyer. I think what you have to tell a buyer is, look, you have to understand enough to be able to give them the what I would call the elevator speech. And the elevator speech should look like this or sound like this. You're buying into a home, or you're looking to buy this home that's deed restricted. And that can have a lot of different implications about what you can and can't do with the property. And because there is an association, it could have a lot of financial implications with regard to the value of your property and future value. So there's a bunch of stuff that, is in your interest to take a look at before you buy. I'm not an attorney. I am an attorney, but you guys should say I'm not an attorney. And if you have questions about this, it's against, I'm not allowed to give legal advice, but I can certainly point you in the direction of some attorneys who could help you. If you guys ever want that, I don't do a lot of this type of consult anymore, but I will give you names of folks that do, especially if they're super concerned about some particular issue. They really, may want to talk to somebody. or it's just a matter of stressing to them that they really should read and take a look. A lot of the stuff is straightforward. So it's going to say you can't have your dog, or you can't have a dog over 50 pounds. If they never look at the stuff, they're not going to see that. So you've got to at least give them that elevator speech of that this stuff could really affect in a lot of different ways your use of the property. And if they say, oh, condo associations always do this, or they never do that, or they can't do that, I mean, you should have red flags going off in your mind, because every single one of these communities is different. Every single one, you have to look at their specific documents that we're talking about to be able to know what a person can or can't do, or even like, I didn't even touch on this, but what you're responsible to pay for. It's not, every condo doesn't mean you take care of the roofs because it's a condo. That doesn't mean that. You have to look at the documents for the particular association. And I'm getting kind of into a lot of the topics I covered during that long class, but if your client is making absolutes about, oh, it's a condo, you never have to insure this, you never have to maintain that, you always do this, I mean, that should be a huge red flag to you that you need to be recommending they look at the documents and consult with counsel if need be, because that's not how these places work. It's not an always or a never situation. It is specifically dependent upon each community's documents. And those documents get drafted by an attorney when the developer builds the property, and they can differ depending upon what that developer wanted to do. Okay. We've got another question from David. Just as a baseline, what would an attorney review of said documents cost? You know, David, that's a good, I don't know that I would hire an attorney to review all these documents. They're gonna give you an hourly fee probably. I mean, that could be hundreds, it could be into the thousands of dollars. I don't know if I would do that. I think if they have a particular, you have to kind of know what their concern is. So what is their concern? Is their concern they're parking their boat outside? Because if that's the case, call me up and I can probably look at it fairly quickly and look at the declaration or look at the whatever and say, and hopefully if you have some relationships with attorneys, like if it's a quick question, hey Marie, can you look at this and tell me if my buyer can rent at this place? If you've got the documents and can shoot them over, hopefully I can help you. I don't do this for every, I do this for clients of Title Connect. I don't have time to do this for every licensed agent in the city of Columbus. So if you have a relationship with an attorney, they may be able to help you out with basic questions to get someone to say, just do a review without giving the attorney what they're concerned about. That would be very, very costly. Now, like a lot of things, I think you have to give the recommendation for them to do that, whether or not they choose to or not. They may find out it's way too costly and they might make that decision they don't want to, but that's not your decision, that's their decision. So you have to give the recommendation to seek counsel if they have questions. It's up to them to get the cost quote done. But the bottom line is, you know, you guys can't risk your licenses by being attorneys or playing attorneys and trying to interpret this stuff. So I know that that's a, you know, that's an attorney type answer I just gave you. It would be pretty costly to just say, hey, review all this stuff and tell me if you're concerned. Some people might want to do that depending on the amount of money they're spending. If they have spare money laying around, they want to pay an attorney to do that, great. Maybe they've got a friend or a family member that'll take a look at it for them, great. But again, the recommendation for you guys just to make, just like anything else, any other legal question someone has, your job is to make the recommendation. They seek counsel and then let them decide if they're going to spend the money to do that. And again, for clients of our company, I don't mind answering a quick question if it's something I can easily look at and it's a very specific phone call type question. David, I hope that answers kind of your question in a roundabout way. I'm keeping my eye on the group chat. Any other questions here? Nothing at all. I see Joanne that you're on here. We've got a broker on this Zoom. I'm gonna call you out. So are you seeing that people are starting to use this new version?
Yes, they are. I would say that more than half of our pendings in the last month or so are working on the new Columbus Realtor contract.
Okay.
I don't know if they're detailing the homeowner association, condo association docs or not though, because I don't see them
Right.
in any of the loops. So, and
So, yeah, I
I
guess,
can tell you the kind of thing though that comes up that personally has happened to me is I had to back out of a contract years ago, maybe 10 years ago, because the prospective buyers were intending to live in this 3-level condominium in Pickerington with a walkout lower level with their adult son, who was recently divorced and has a child who visits quite often, in the lower level of this lovely condo in a gated community. And luckily, we did get all those documents from the listing agent, and we bailed because there was going to be a constant fuss with the neighbors about cars in the driveway
yeah,
and about his entering and exiting the home through the sliding glass door of the lower level of the property.
yeah, that's what I mean, associations can restrict stuff that you wouldn't even think of. So without knowing, without looking at the specific documents for that place, you'd have no way of knowing those types of restrictions. Parking is a huge issue. It sounds silly, but if you're moving into a place that doesn't allow parking on the driveway, some of them say you have to park in the garage, you can't be on a driveway overnight, and you've got more cars than you have space for them, that's a huge issue. So it's stuff that people don't even really think about unless they take a look at those documents.
Right, and there was one condo association in Powell, maybe it's changed, but the only color flowers that you could plant or hang in a planter outside your home had to be white.
Oh boy, yeah. I mean, mailbox colors, flowers, some of them say you can't put any plants out. I've seen people get in trouble because they did like the topsy-turvy tomato outside. You can't have that. There's all sorts of crazy restrictions. So unless your buyer has seen the docs, and of course, if nobody, I mean, on a very basic human level, nobody wants their client to move into a place and be completely miserable and looking at you saying, why didn't you tell me that I couldn't do all this stuff? So that's why I said you've got to be able to give that elevator speech to at least say, look, you really should take a look at these because it impacts what you can and can't do once you move in. And deed restricted communities are all different. And this will let you know what this particular community allows and doesn't allow. So you have to give some kind of warning like that to your client to get them to take a look at these docs, hopefully. Sorry to put you on the spot, Joanne, but thank you.
No, I'm glad to see everybody, or kind of see.
I know, it's nice to see people.
I see Stacy, I see Casey. Oh, do you remember Romper Room?
Yes.
And I see Stacy.
I might have to do that on my next class. We have to require people show up with video, I think, so that the state, no, I'm not doing it on this because it's not an actual CE, but we have to require people turn their video on next class. This is an interesting way to communicate. I hope that we all get to do it in person sometime next year, hopefully. Or I unfortunately don't think it'll be sooner than that, but hopefully early in 2021 sometime. Okay, any other questions, guys? So it's not, you can see that it's not major changes elsewhere in the contract. This 6.5 is really the big one. Be aware, as you know, if you're the listing agent, be aware when a contract's coming in, which version they're using, because I've got the question a lot, like, well, what's the date we have to start using this? There's no set date. It's just that most people will start transitioning, and eventually the old contract will be, I'm assuming, taken off of people's, online contract databases, and you just have to be aware of which contract you're being provided so that you're not taken aback when all of a sudden a buyer is trying to terminate because you didn't provide them all this stuff. Okay. So my email and phone number is on that chat. If you want a copy of the annotated version, like I said, I think if you get the In Contract magazine, I'm pretty sure there was an article, and maybe even, I don't know if the annotated version was in there. I've been out for a while on maternity leave and just got back recently, so I know that this stuff went out somewhere, but I have copies of it, so I'll be glad to send it to you if you need it. Shoot me an email. I think that's it. I hope everyone's doing well and making it through these crazy times we're in.
Thanks, Marie.
You're welcome. I'll hang around for a couple minutes here. If you have questions, let me know.
Thanks. Bye-bye.
Bye, Joanne. Thanks.
Hey, Marie, actually, I did have a question for you. So we
Yes.
had one condo we were trying to get in Dublin. The question was, I said I was going to ask the person for the agent for documentation before we went to contract, because he was trying to possibly have to rent it because he was going to have it as an investment property, and we want to make sure that he was able to do so.
Right.
But she said she would not give us any of the documentation until we went into, or until we submitted a contract. Does that seem off to me?
Yeah. I mean, it just doesn't make sense. I don't know why they wouldn't be able to share it with you. It's the seller, like I said, the owner who has the legal right to get it, but once they have it, they can share it. There's nothing stopping them from sharing it with the prospective purchaser. And I think who wants to waste their time writing an offer if you know that that's a disqualifying, if you can't lease, you know that's disqualifying, why waste your time going into contract and having to do all that? So to me, I mean, there's nothing obligating them to, but I don't know if I don't know why they wouldn't want to give it to you so you could make that determination before going into contract, especially if you're going to do earnest money, because why get that tied up too and have the off chance that some seller is going to be ridiculous and not sign off to give it back to you over something that you know you're going to have to terminate if you're not allowed to lease.
And that's a question. I was wondering why I don't see more of those the documents aren't in, like when they have the stuff for MLS, just, you have the property disclosures and stuff in there, but you'd think that they'd want to have some of that information in there. But I've been looking a lot.
I mean, the goal of these changes is so that over time you start seeing that it becomes customary that stuff would be there. It certainly hasn't been up to this point, and that's one of the reasons these changes were made, because I think the problem is a lot of list agents don't know how to get the stuff. They don't understand that they're not going to get a response when they're calling the management company. They don't understand their seller is the one that legally has to make the push to get it. So a lot of the goal of all of this is to educate list agents and get them to start getting all of this stuff in advance.
All right, thank you.
Jacqueline, thank you very much. I'm lucky I don't hear her screaming in the background so far. And then Bob says, when is that class? It is later this month on, sorry, I keep having to get this out. Should mark this date. It is September 24th, so Thursday, September 24th at 9 a.m. And if you are not on our class list, you can, I'll put this again in the comments here. Ooh, I might put it in the comments. Thursday, September 24th at 9 a.m. until noon. If you are not on our normal email list to get, presumably if you're here, it's because you're on our email list. But if you're not, and you're not getting emails about our classes and you want to be added, then you can email Celia. And I'm going to put her email here. And just tell her you want to be added to our email list. And then you'll get, you'll get all the promotions for future classes. Okay. I think any more questions, anybody? I have to give you warning on that 3 hour, you gotta have your video turned on. I just found out the state wants to see that done so that we can make sure people are actually there and not getting CE credit, for doing something else and just turning their Zoom on and leaving the room. Not that any of you would do that, but we have to make sure that we're giving credit if you're actually in the class. All right, thanks for being here, folks. If you guys need anything, I've given you emails and phone numbers to reach myself or Celia. We're glad to help out. Have offices in Dublin, Grove City, Westerville, closing locations. So we're glad to help out however we can, and we look forward to, again, seeing you guys in person, hopefully sometime soon. Yeah, everyone have a good day. Thank you.